do hope that some of you got a break. Before we start, I haven't finished marking. I probably will finish. I actually genuinely believed it when I said I was more than halfway through the other day. It turns out I'm more than halfway through the face-to-face class. I am not actually more than halfway through the whole lot. But I'm on a roll. They will get done. They do take time to do. You deserve more than just a tick and flick. But you haven't got them yet. We also have, unfortunately, terrible cold and flu season. I'm not going to out anybody, but we've had a couple of people who've been really, really unwell. We had a couple of people in hospital. We've had some pneumonia. Anyway, so we have a couple of people who haven't actually submitted yet. So for that reason, I don't actually want to share too much about what the answer is. So I am putting time aside next week to actually work through the problem, to give you overview feedback. What I can say, and yes, I did hit the halfway point. I am literally one more than halfway today. One more than halfway. But it's a big enough sample size for me to say that they're really good. Like there's, I'm at the halfway point and nobody has failed yet. Doesn't mean you're not in the second half, by the way. Just so you know, could be you, but nobody has failed yet. And I think I'm looking at a range of marks so far where the lowest is at the high end of the 50s. So I haven't seen that before very often. So, and I'm where I'm at now, there are certainly more distinctions than anything else. So I'm feeling pretty good. Clearly, I just taught you really well, or it was probably the one thing I will say about it for those of you who are overthinkers, like I know it's rare amongst law students for you to overthink, but just in case there are any in the room, probably the biggest problem that you guys had is the problem itself was probably too straightforward and simple. So there are probably where some people fell apart was just trying to find some trick in there, because it actually probably wasn't a trick there. But yeah, I'm really happy with them. So that you know about the way I mark, I do not mark them in alphabetical order. I mark them through this strange algorithm that I don't even understand, and when I mark them, I turn your names off. So I don't actually, look, clearly most of you have put your name, it's a memo up the top, but I try and skim past it and not look. I just try and mark who you are. So sometimes my comments might seem a bit odd if you know that I know who you are. Like 4 things, for example, a comment, I know I wrote one today and I thought, well, if I've got this wrong, I'm going to be in trouble, but it was something along the lines of, I suspect that English might not be your first language. And so if it is your first language, because I turn the names on afterwards and go back and do the comments afterwards. So if it is your first language, then chances are I won't have pulled that out because I won't have known your name when I made the comment. So I just thought I would just point that out to you. There are some scientific reasons for doing that in the sense of it just pulls out any bias that I might carry consciously or unconsciously, or makes me deal with it in a different way. I do have some pretty strong prejudices, I know that. People who put apostrophes in the wrong spot, or just put apostrophes in every word, I really have, I haven't seen any of those so far, but yeah, I have very strong bias against that. People who on social media use the word your as in something belongs to you when they mean you are, yeah, I'm very biased against those people. I just think I should be out there and open about these things because you need some certainty about what you're dealing with, and that's how I'm going to segue into talking about certainty. So 2 topics this week, right? So we are going to do a flying race through the key themes. And there is a possibility, depending on how many questions and where we go. If we don't get through it all, we're going to need to finish it in the tute next week. I'm at home now, so for those of you who came to the tute while I was in Vietnam, you got to, the recording doesn't show it, I don't think, but I'm videoing the guy who's trying to help me get onto the internet. Turned out that was because it was a public holiday there, and they often throttle the internet on public holidays just in case people are trying to organise protests or something, or so I'm told. I'm very gullible, I can believe all sorts of things. It was public holiday, and it was just, I wasn't able to get on. So if you came into that tute and nothing was happening and you left, it was because nothing was happening because I couldn't get in. I was at least 15 minutes late, possibly more. So that's why we had the makeup one last night. But those recordings are up. So certainty is the last of our formation elements. We need certainty in order to have an agreement. Some people tend to bundle the idea of certainty up with either intention or more likely offer. And the reason for that is, in order to have an agreement, we need to have an offer that is capable of, on acceptance, becoming an agreement, which means the DNA of the deal, that's my expression, nobody else's, the DNA of the deal needs to be wound up in the offer, which means that the essential terms need to be clear, in particular what the consideration is. The fact that the parties intend to be bound needs to be wound up into the arrangement. And ultimately those things to an extent go to certainty itself. But ultimately certainty is worth exploring by itself because it's the requirement that the parties set out their respective obligations. And we need to know, if there is a contract, what the contract is, what the subject matter of the contract is. And certainty itself, oh, sorry, I thought I was going to go in a different place, but I'll just follow my slides. So just going back to this, when you're solving contract problems, you're basically dealing with this, starting off with this question, is there a contract? In the vast majority of contract law disputes that you will read cases about or that come before the courts, there is no dispute about whether a contract exists or not. We've just spent 5 and a bit weeks exploring this whole nature of what a contract is and looking at all of these cases that really are just the pinnacle. They're there to demonstrate to us what a contract is and what a contract is not. But usually, if somebody sues you in contract, there will be a presumption that a contract exists, and the onus of proof that there is no contract will be on the party claiming that there is no contract. And again, that's consistent with what we've been talking about so far. So when we're dealing with contract overall, you're starting with, is there a contract? Who can sue for that on that contract? If there isn't a contract, is there some other way to enforce the promise? What are the terms of the contract if there is one? And particularly if they're written down, how do you actually construe them? By construe here, I mean understand them. What will a court understand? So again, the language we use there is the construction of a contract. I always find that interesting from the very beginning because construction suggests to build something, and yet to construe a contract literally means to pull it apart and understand the terms one by one. And it's just, I guess maybe that's just how I remember the terminology. It's so long ago I don't remember, but I've always thought that's kind of interesting. And then ultimately, probably the most important thing overall is understanding what the specific rights and obligations of the parties are in this particular circumstance under this particular contract. And so basically this semester, to this point, we've only been looking at the first of these. And that's what we're going to complete in the first half of today. It's next, we're going to go on to this idea of who can sue on a contract. Actually, not even straight away. That'll be when we deal with privity, I think, next week. we're starting to then look at some of the other elements like, well, formalities is what we're doing with the rest of today, is understanding the circumstances even when you have a contract that a court won't pay attention to it. From your textbook, the cases reflect the tension between, on the one hand, the desire to hold parties to their bargains in accordance with the principle pacta sunt servanda, agreements must be kept, and on the other hand, the court's reluctance to make a bargain for the parties. And I think if you take nothing away from this topic, come back to this quote. Because ultimately certainty is about making sure that the agreement that your clients have reached is sufficiently certain so that a court can make sense of it if they need to. Or even better, so the parties can make sense of it if they need to. If you go right back to our first week, I'm pretty sure I talked about backyard cricket. A lot of what the contract, a written contract is like the rules of that game. Subject to you not hurting other people, and on the basis that you pay the tax that you need to pay, chances are, while things are going along well, if one party isn't doing everything that they promised, or one party suddenly decides that they want a little bit more than they asked for the first time, you can usually work it out. It's only when the parties are at loggerheads that you need to go back to the original source of the agreement in order to work out what the rules are. So we remember these steps, right? You should be saying that mantra in your sleep now. The elements of a contract are agreement. It's made up of offer and acceptance, unless you can't find them, and then we're looking for a consensus or a meeting of the minds. We need to have consideration. Consideration is something that is paid by the promisee for the promise. It's the price of the promise. There is a difference between consideration and payment. Consideration in most cases is a promise to make a payment. So the obligation is the payment and the consideration is the payment itself. Intention. Did the parties actually intend for their agreement to have legal consequences? Really, in that context, we look mostly at what kind of relationship did the parties have and what was their intention determined objectively. And then lastly, certainty, and that's what we're covering today. Have the parties, there's a word missing from that slide by the looks of things, have the parties clearly identified their rights and responsibilities. But in the way of contract law, it's so much more. There are three elements to the idea of certainty. Firstly, any agreement, and I'm using agreement there as the verb. We can come down to the question later about whether it's in writing or not in writing, whether we're using it as a noun. But it needs to be sufficiently certain, sufficiently complete, and not illusory. So we're going to explore each of those one by one. They're talked about as being the certainty requirement, but they're actually slightly different aspects. So, one by one. Before we go into each of them one by one though, there's always a little before, isn't there? Just want you to be aware that in order to meet the certainty requirement, you do not have to identify every potential twist or turn or outcome. It's not necessary for the parties to provide for every possible contingency or to articulate every possible contingency. It is also not a requirement for a valid contract that the terms be expressed in a way that it's that there's only one way of reading them. Courts will, to an extent, fill in the gaps. So a lot of the literature and a lot of the cases that you're reading in this one, you will see that expression coming up over and over again, gap filling. What is the obligation of the courts or the role of the courts in filling the gaps? In interpreting contracts, the courts will use, and this is, we're high on Latin this week. This is the second. I think there's at least 2 more to go. Use the maxim ut re magis valeat quam periat. You can, if you wish, pick me up on my Latin pronunciation, partly because I find it amusing that people do that when it's a dead language, people. Dead. The maxim, it is better for a thing to have effect than to be found void. So we've seen that from the cases for a very long time. So a court starts with the presumption that it is better to read or to look at a situation with a view to finding a sensible something than it is to just push it away. So when they look at, if it looks like a contract, if the parties have acted as if they're intending to enter into a contract, then the fact that it is difficult to read that contract means that the courts will work hard to find a way. But if it doesn't look like it's a contract, if there is other objective evidence that suggests that there is no intention and the wording is loose and difficult to understand, then they're more likely to think, well, actually it's better for a thing to have effect than to be found void, but this thing doesn't seem to have an intention attached to it. So my little mud map of what we're doing, I'll come back to it several times, but this might help you understand as we go through each of the different elements. So certainty can fall over for failure of any of these. So you need to ensure that your contract, your agreement is sufficiently complete. You have to avoid it being vague or ambiguous, or so vague and ambiguous as to not make sense. And you need to ensure that the promises are not illusory. And I'll get to that towards the end, but that'll make sense to you because you're all very comfortable now, I hope, with consideration, and illusory promises actually fail as much for a want of consideration. So here are my sections. So let's first talk about terms being complete. Okay, so to do this, we need to ensure that agreement is reached on all the essential terms. So that's what I'm focusing on here. I was trying to think, sorry, I paused there because I was wondering what my animation was going to do. But I think I've just, for some reason it's animated and just this slide will keep coming up. And this one we're talking about completeness. So some people will argue that completeness itself is not actually a formation element. They say that an uncertain or incomplete agreement can't be enforced because you didn't actually reach agreement. There wasn't an offer that was capable of being accepted on its terms, or that you didn't reach agreement in relation to, in particular, consideration. Completeness means that only means here that the parties need to have set out the essential elements of their agreement or specified a way of working out what those key terms are. So a contract will be enforced if the parties' intentions are clear, or you can ascertain what their intentions were with some certainty based on the formula that they've provided. So where completeness comes together is in relation to where a particular essential term is missing. So one of the essential terms, it will not surprise you, is consideration. In almost every case, what the obligations of the parties are, the key obligations, will be an essential term. And one of the reasons for that is a contract's going to fall apart if we don't have consideration anyway, right? Unless there is a price for the promise, we do not have an agreement. So if it is unclear what the price for the promise is, then we don't have consideration, but we also have a failure of certainty. Case in point here, though, is Whitlock and Brew back in 1968. there was an agreement in relation to the sale of a property. This is a particularly interesting property. From memory, it's out the back of Altona. Have any of you been out, you know, if you go over the Westgate Bridge and if you're heading out towards the west, you look down on the right-hand side and there are the big petrol tankers. Yeah. One stage my daughter rented a house diagonally opposite them. I was convinced they were going to explode every night, just randomly. So basically this land, I'm not sure if it's that land, that's just the one that's in my head, but it's in that area, and it was land that was being designated to put in these petrol tankers, and the idea is that it was going to be leased then, so it's being sold to the purchaser, who was then had promised to lease the land to Shell, the oil company, for storing aviation fuel or some kind of fuel on, and the words were, on such reasonable terms as commonly govern such a lease. So lease terms are pretty easy to work out what they are, right? We've got some property people in the room. We need to know what the rent is. We need to know what the term is. But this is a particularly unusual type of lease. It's for using the property to store, to build something that's quite unusual. These petrol tankers, there's an environmental, well, it was probably in 1968, they probably thought about it less than now, but there's an environmental impact on the land. There's all sorts of unusual features about it. So ultimately, the question before the court became, was this promise that they would rent such part of the land to Shell on such reasonable terms as commonly govern such a lease sufficiently certain? Was it a certain and complete term? And ultimately, what's reasonable or fair can be impossible to work out. The judges themselves might not even agree themselves, and understanding the uncertainty in a particular case can be significant. So in this case, it was held that the expression upon such reasonable terms as commonly govern a lease wasn't, in the context which it appeared, apt to refer to either the period of the lease or the rent payable. So there was only those terms. We don't know, is that a lease for a month or is it a lease for 10 years? We don't know what the market rent is. Now, it's quite likely if that term had been on the basis that you rent, you know, you've got a house and it says that you rent out the house to Scott here on such reasonable terms. Actually, we can have a look. There are thousands of residential retail leases. We can pick the price. We can look at them and say, okay, the average in this area is X. You can get a couple of quotes on it. And most residential leases in this area are for 12 months. You know, we can work out what the key terms were, but in relation to this, they couldn't. So it was insufficient. It wasn't sufficiently complete as to what the terms were, and it wasn't sufficiently clear as to what that meant. So, in order to work out whether or not a term or a group of terms is sufficiently complete, we need to identify what the essential terms are. Because unless we know what kinds of terms are essential terms, we can't know whether something is missing. So some are pretty clear and happen all the time. Who the parties are. Who has the obligations or who has the rights under this agreement. And we'll probably understand more about that when we get to privity. But in particular, who the parties are or what the class of potential parties are is usually an essential term, rarely wouldn't be. The subject matter of the agreement. If I'm selling apples, and I'm agreeing a forward price for selling you apples over a period of time, I might not have to specify which apples, but I will need to specify probably what type of apple. Are we Granny Smith or are we Jonathan or are we Fuji's? What kind of apple is it? I might need to specify, or we need to have some sort of understanding of the provenance. Like, apples from Tasmania as opposed to apples from China. Or a level of freshness or something like that. The subject matter will vary from one arrangement to another. If I'm selling you a house, if we enter into a contract for $1 million and I'm going to sell you a house, I show up the next day with one of those little red brick houses from Monopoly and ask you for my $1 million, I think you'll be arguing that maybe the contract wasn't sufficiently certain. Now, again, there is a little bit of leeway there, but on the whole, and houses are an interest in land, so formalities apply in relation to them, but we need to specify which house, like the address, the lot number. Now, it might be that if I'm selling you my house, and I only have one house, and we all know what that is, it might be sufficient to say your house or my house in the agreement, but we do need to be able to identify what the subject matter is, and the kind of subject matter, how the level of identification will change. Consideration, I'm going to come back to that. Price is usually a key term or an essential term. If it's not the exact price, a mechanism for working out what the price is. So it might be that I could specify the rent, $1,000 a week, or I can specify a future rent as, the current rent plus an amount equal to CPI, all ordinaries, Melbourne area for the period between now and when the rent review is, on the basis that the rent will only go up. So if CPI is 0 or negative, the rent will stay the same. That would be a formula for identifying what the price is. I could say I need $1 million for every time I teach this class, or I could say I want $100,000 from each of you. Actually, we pretty much get that, don't we? Wish it came to me. So whether an absent term is essential or not depends on the nature of the contract itself and the circumstances. So Luna Park, tramways in Luna Park, have I got a slide about it? Probably nothing more than this. Have a look at this while we're looking at it. So tramways in Luna Park, was it Luna Park? Luna Park is, actually, was it Sydney? It might be the New South Wales Luna Park and New South Wales trams. Oh, yeah, thank you. It's been a while since I've read it. And so Luna Park basically signed up to advertise how much fun you could have at Luna Park on the trams as they wandered around. And the clause basically spoke about that their advertisements would be on the trams for a minimum of 8 hours a day. And tramways basically tramways didn't actually control how often the trams moved around. So they controlled putting the advertising on the trams. And it turned out that they didn't meet the minimum 8 hours a day requirement, but on average, the trams with this advertising were out and about for 8 hours a day. So it wasn't a minimum of 8 hours a day. So there were some days that were less, but then there were some days that were more. So over a period of time, it was 8 hours. But Luna Park said, well, actually, that's not good enough. This is an essential term. So, and tramways had admitted that they hadn't always met the minimum requirement. Now I'm probably burying the lead a little bit in my explanation here, but another thing that you need to understand is that if a party breaches an essential term, the other party, the party having the benefit of that term, has the right to terminate the contract. If a party breaches a term that is not essential, the party who has the benefit of that term has a right to claim damages, but not a right to terminate the contract. And then just because we're lawyers and we like to make things as complicated as we can, there can be these inanimate in the middle terms. We call them inanimate terms, which aren't necessarily essential and aren't necessarily not essential. And the way that they work is If you breach them and the consequences are catastrophic, then the other party can terminate. But if it's only mild consequence or a lesser consequence, then they can get damages. Now, you're thinking, well, how's that different from essential terms, really? But let's carry this on. And in Luna Park, it was just a requirement as to time. Really, is there a significant difference to Luna Park if they get a minimum of 8 hours or an average of 8 hours? Is there really a significant difference to them? But because it was an essential term, well, they argued successfully it was an essential term, they had the right to pull the contract. Now, their damages would probably be quite small, but they could pull the whole of the contract. So, whether a court can enforce the contract where we're looking at it here is from the point of view as whether the court can enforce the contract if it's missing an essential term. So in order to understand whether they can do that, we need to understand what the essential terms are. And so Luna Park's good authority for this, but I think a good working example of thinking about the difference between essential terms and, by the way, other terms that are non-essential tend to be called warranties. And warranties is used in two ways by contract lawyers. So when you get into advanced contract, or if you do M&A with me over the summer, we will talk about warranties as in a kind of promise that a vendor of goods makes that, again, it's not necessarily an essential term, but usually there is some monetary compensation. So let me give you an example. If I am going to sell my business to you, I will give you a warranty that, say I'm selling the company, I'll give you a warranty that less than 2% of my customers pay their bills in 90 days or more. So 98% of my customers, they pay within 90 days. So cash flow, it makes a big difference to people. You buy my business, you find out it's actually the other way around. 90% of my customers take 90 days or more to pay. That actually might be a significant negative for you in buying the business. It might actually be catastrophic, but we will have agreed it as a warranty. If it turns out to be untrue, chances are we will have a formula for calculating what your damages are. Just go off-piste for a moment. So what kind of examples of things that have been essential or non-essential? So we have seen lease agreement where absence of information about the commencement date or the amount of rental that will be paid have meant no contract because they are essential terms. Sale of land agreements where absence of terms about the parties, identification of the land itself, the price, all of which have resulted in a no contract because there's been a lack of completeness, a lack of an essential term. Sale of goods, which goods? Although interestingly, under the Goods Act, if you fail to stipulate a price in relation to goods, in Victoria at least, the Goods Act will imply a reasonable price. And that somewhat reflects common law when it's easy to work out what those terms would be. Apart from the fact that the general purport of the communications in relation to this particular matter evidence anything but an intention to affect legal relations, those documents deal with only some of the terms which of necessity be settled before a binding contract can exist. No contract is concluded until the parties negotiating are agreed upon all of the terms of their bargain, unless the terms left outstanding are such as the law will supply. So the court will not make a bargain for the parties. Now there will, and towards the end of our 12 weeks together, we'll start to talk about implied terms, and there are terms that will be implied by law. So, for example, at common law and under legislation, if I sell you a thing to do another thing unless I've been very clear that that is not the case. The thing I sell you needs to be fit for the purpose that you bought it for. So if I sell you shoes, there is an implied term that the shoes that I sell you are fit for walking in, unless it's very clear that that is not the case. You know, I'm selling you antique shoes, or they're not going to fall apart. So, when is a contract incomplete? We need to work through the essential terms to work that out. I have made a little list here of some cases that will help you get there. How important or essential is the missing term? Could you have an agreement without that term being used? Why was the term left out? So if a term is left out because the parties have been negotiating and failed to reach agreement on the term, then it's clearly not an essential term, and their agreement may well still be complete. Has the agreement been wholly or partly performed by one side? Now, a court is loath to find that there is no agreement for any reason, but particularly for a lack of certainty, if the other party has done everything they need. So if we agree that I'm going to sell you apples, and we are a little unclear on what the price of those apples are going to be, but you've got the apples, you've accepted them, I've handed them over, and there is clearly, it's easy to work out what the market price for apples is, even though our documentation, we might have left off the price off the email exchange or the documentation, or when we were talking about it, we might not have actually specified anything. Court would be very reluctant to find no agreement. You've already got my apples. They're now either eaten or somewhere else or rotting away somewhere. I don't want my apples back. I want the money for them. And then also, and Milne, the case we were looking at just a minute ago, goes to that question of how well equipped the court is to imply a term. So if it's easy to pull it out, again, the apples example, you can get a market price for apples. But when we're talking about Whitlock and Brew, what would the negotiated terms be for renting out petrol tankers on a piece of land? That's not something that the court is easily able to do. Mentioned this earlier, I used CPI in my example as well, so I'm going to rush here, but we're particularly specifying price. We don't necessarily need to have a price. Having a formula for working out what the price will be will often be enough. And I mentioned, actually, we can agree to sell something at a valuation as well, and this is embedded into the Goods Act. So it might be that I agree to sell you all of the furniture in this room at the end of semester. And we agree that we'll just get a valuer in to work out what the market price is, and I'll sell you the furniture at market price. Good deal for me because I don't own the furniture. You can see that that'll work really well. And that's encapsulated in the Goods Act here. So whereas an agreement to sell goods on the terms that the price is to be fixed by a valuation of a third party, and such third party cannot or does not make the valuation, the agreement is avoided, provided that if the goods or any part of them have been delivered to and appropriated by the buyer, it's always a he must pay a reasonable price for them. Okay, we talked about this a little bit not last week, the week before when we were here, this idea of an agreement to agree. So an agreement to agree can never be enforceable. And it really goes to this idea of certainty. So what does a promise to negotiate in good faith the precise terms of a more comprehensive joint venture agreement, what does that mean? That suggests actually that where we're at now, there is no intention to be bound. Parties are to mediate, I was about to say meditate. Wouldn't it be better if they did more meditation? Parties are to mediate in the event of a dispute arising out of this agreement. Again, as you know already, the parties cannot slice out the jurisdiction of the courts. The courts need to have jurisdiction. The parties can agree that they will go through a process, but if one party thinks that we need to actually get an injunction or take quicker action, we cannot actually require that we go through that process first. What will actually happen in practice is the court will send you back to go through the process unless there's some kind of urgency. So, where are we going? There are some cases where an agreement to negotiate has been upheld, particularly if it's an agreement to negotiate in good faith, as long as the promise itself is sufficiently clear. But an agreement to actually end up with a particular outcome, so we will agree the precise terms under which I will sell this thing to you later, that is not sufficiently certain. We need to actually have everything. But we will negotiate in good faith, that will be upheld because we haven't agreed to agree, we've just agreed to negotiate. Question, Ken?
Agreed to negotiate, what does that actually, I guess, what's the purpose of that? Why would one have an agreement to negotiate?
Because what we're trying to do, different context. So if I was trying to sell something to you, you might want me to promise I won't sell it to anybody else for a period of time while we negotiate and agree a price. So I actually want you to negotiate in good faith. I don't want you to just use that as a stalling tactic so I can't sell. So we've agreed that we'll get around the table. So you would be in breach of that agreement. If I'm keeping my promise and not negotiating with anybody else and you refuse to come to the table, I would be able to sue you on your failure to negotiate with me. I can't make you promise that we'll end up at the end result, but if you're going to negotiate in good faith, does that make sense? Another way of looking at it is if we're actually in a contract together, the clause might say that we agree if we have a dispute that we will negotiate with each other before taking it to court. That will be enforceable. But if it says we will never go to court, we will only negotiate with a view to getting to an outcome, that's called Donald Trump, and it doesn't actually apply anywhere else. Okay, any other questions there? Because I am planning to fly, as you can tell through this stuff. So the next one that we're going to talk about is, now that it's complete, is it actually certain? And we've touched on some of the certainty aspects as we've gone here. So here what we're doing is assume that we've got something that addresses each of the essential terms that we need. The next question becomes, is the language sufficiently clear? Now notice I'm using that legal catch-all, sufficiently clear. Consideration needs to be sufficient, it doesn't need to be adequate. The terminology needs to be sufficiently clear, but that doesn't mean that it has to have no ambiguity at all. So if agreed terms are sufficiently certain and clear, parties will be able to understand what their rights and their obligations are, and the courts will be able to enforce those rights and obligations. And this is because the parties need to be able to identify what their obligations are with some kind of precision. They need to know what it is that they need to do. So, Mohammed, you work in construction, don't you? Yes. Yeah. So, in particular in construction contracts, you can end up with these really massive schedules that will be really, really specific about the colour of the, well, not just the colour of the tiles, the actual specific tile that can be used, or the taps that are used, or the standard of chip rock or fire retardants and all of those things. So very, very specific. So you know without a doubt that if the contract says that you have to supply, 15 square metres of tiles, you know exactly what that means. I provide legal services at the beginning of every engagement. The law requires me to exchange with my clients the document that I call the document that you need a lawyer to advise you on, so you can engage a lawyer to advise you on their terms and conditions. It's like this big circle because they're quite complex. But the reality is, if I'm giving you advice and we're at the beginning contract, I don't know what that advice is going to be yet. So, and in fact, the nature of the kind of advisory work I do, things can change. So we will have something that sort of encompasses, I'm going to look at this information that you've given me and give you some advice, and then I'll follow your instructions in relation to the next step. But I can't know for sure that I'm going to be writing 2,000 words and delivering it by such and such a date. That's not a KPI that ever hits any of the agreements. So they can be quite different, but equally enforceable. Courts don't usually take a narrow approach to the requirement of certainty. They'll attribute, a meaning to language unless it's really impossible to do so. So even when there might be multiple ways of reading something, I saw an example of this the other day, and it's just where a word could mean two different things, but in context it's really clear which one it means. Courts, again, will take the sensible reading in most cases. So how about this one? Like at the conclusion of the contract, you must give us a BOW. Now that word could be bow, as in one in my hair, or a bow, like this. They're like different words spelt the same way, both equally ridiculous in this context, but let's say this is a contract for the supply of hair ribbons. Makes perfect sense which one it is. If it is a contract for the supply of performance services of some sort, putting on a play, then the other will make sense. The court will come up with a sensible meaning. That wasn't too bad for me making up an example on the spot. Well, it's not great, but it's better than nothing. So in order to determine certainty, we look at the language that's actually used. Is the language itself so obscure and so incapable of any definite or precise meaning that the court is unable to attribute to the parties any particular contractual intention? If it can be logically worked out, if not by the parties, then by the courts, then it's not too uncertain. So I think Upper Hunter County District and Australian Chilling and Freezing Company, it was one of the readings in the Casebook, right? So that case is to do with the supply of electricity. In fact, I might have it on the slide, do I? Can't remember. Anyway, look, it's to do with, have a look at it. It's to do with the supply of electricity, and so basically the council is supplying electricity to the refrigeration company. The main ingredient in keeping things cold is electricity, right? You take away the electricity these days and everything that's in the chilling and freezing factory melts. So you need to have guaranteed electricity supply. You have a lot of problems otherwise. Essentially, there's a term in this document that said something to the effect, I'm scraping my memory here.
I think it's your next slide.
Oh, it is my next slide? I see you guys. Here it is. Clause 5 says, it's agreed that during the term of the agreement, if the supplier's costs shall vary in other respects than has been provided in this document, then the supplier, council, will have the right to vary the maximum price for electricity that we charge you by giving a notice to you. So that by notice in writing to the purchaser is just the mechanism for triggering the increased price. So the council basically said, well, we want to put our prices up, and clause 5 says we can do it. And the company said, it's too uncertain. This is an uncertain clause, it just doesn't make any sense. So they're saying that it's agreed during the term of the agreement if the costs, which costs, vary, because we've already got a long list of costs that are there, and it's quite clear if your labour costs go up by more than 2%, then we can put the price up by 2%. That if the energy distribution charge goes up by X, then we can put the price up by X. But they're saying, well, you've got all of these other mechanisms for the things, but this sort of general, like what costs? Everything that we cared about, we negotiated and put in the agreement. Secondly, you've got the right to vary the charge by giving us a notice. Like, vary it by how much? How is that related to how much your costs have gone up? So that was the kind of argument that they were running. And Chief Justice Barwick said, so long as the language employed is not so obscure and so incapable of any definite or precise meaning, then the court is that the court is unable to attribute to the parties any particular contractual intention, then it can't be void. We are going to find something rather than nothing, because if there is something there, it's better for it to be found to be a real contract than to just push it away. So no narrow or pedantic approach is warranted, particularly in the case of a commercial arrangement. There is no uncertainty or ambiguity in the expression what suppliers' costs are, however wide might be the area of possible disagreement as to what it means. We know that they are costs that the council had. So, whether something is reasonable or unreasonable can be unreasonably difficult to work out. So, what's a reasonable price for the goods? Reasonable to whom? Reasonable to the seller or reasonable to the purchaser? What's a fair and equitable price for services? Concepts like this are inherently precise, but the courts do their best and they pull in valuers, and ultimately the cases will be pitting two different valuers against each other to try and work out what the midpoint is. Hall and Bust, again, authority for that idea that, look, at the end of the day, this stuff is hard. Not every judge will agree, but we are better to find something than nothing at all. Questions, concerns, frustrations?
Maybe I'm misremembering this, but I thought that courts didn't want to see if the price was reasonable or not in terms of the contract. They just wanted to see that.
Really good point, because it's actually you are absolutely remembering correctly that a court will not inquire into the adequacy of the consideration. But if we're trying to work out what the consideration is by having a formula, and the formula is, I'm going to sell you all of my apples. Okay, you have the right to buy all of my apples, and we will determine, you're going to pay me a reasonable price for those apples based on market prices in the next 100-kilometre area around my farm. So that reasonable itself is a little bit, because yeah, we can look at market price, but market price might be determined by a range of factors, and my apples might be just slightly better than everybody else's. Or it might be that my apples are really crap, and a reasonable price for my apples, because they're only really suitable for canning and stewing, is a different price than, you know, his apples, which are going to market. So we've got, again, we're not certain on what the consideration is, the number. We have agreed it's going to be a reasonable price, and then our fight is over what reasonable is. But if we were completely silent on the price, we would need to pull in the Goods Act to say, well, actually, if these are goods, if it falls within the definition of goods, then a reasonable price can be implied by a market valuation. Did that help?
Yeah.
Yep. Good question, because I can see how easily I must have misrepresented that. So the last thing I want to talk about before we go to the break, which is going to be really quick because we should have had a break pretty much already, is to be certain terms must not be illusory. And we've kind of talked about this in the context of consideration. Consideration needs to be sufficient. It doesn't need to be adequate. So consideration is, as you remember, the price for a promise. And almost always in a bilateral agreement, the price for a promise is another promise. But if your promise is so discretionary as to not really be a promise, you fail for a lack of certainty, but you might be failing for a lack of completeness as well, consideration as well. So it can also overlap with that idea of the honour clause in intention. So something where you say, well, I'm intending to do it, but I might change my mind. I've promised to do it, but I'm not obliged to do it. Now, where I think a lot of this stuff comes up is when So say I make a promise I'm going to give everybody in this room an HD if I feel like it on the day. It's like, it's completely discretionary promise. It's completely up to me what promise I'm making. And so I'm going to hire you, and I'll work out whether I pay you or not at my discretion, and what your role will be, and whether I even put you on the books or not, or give you a contract at my discretion. It's a promise where I say I'm going to give you a job, but I've got the discretion to change things. You can come and stay in my house and pay me rent for as long as you like, until I change my mind and I say it's time for you to go. Completely discretionary promise that may in fact not be a promise at all. So in place of development, again, it's worth noting that this is a contract with the government as well. The Commonwealth agreed to pay a timber company a subsidy if they exported products from the territory of an amount or a rate that it would determine from time to time. So Justice Kitto says as a general principle that wherever words which by themselves constitute a promise are accompanied by words that shows that the promisor has a discretion or an option as to whether he'll carry out the promise, the result is that there is no promise. So I'll pay you an amount from time to time that I think is the right amount. Now, in some cases, commercially, that just might work. But if we're trying to hold up whether there's a contract or not, because remember, people can pay each other money without a contract. There's nothing to stop people from doing that. Again, as long as you're prepared to pay tax and not hurt other people, you can pretty much do anything you like. But if you want to enforce that ongoing payment, you need to have a contract. And that kind of, you come. You know, I could set up something where I say, come and mow my lawn, and you come whenever you like and I'll work out what I think it's worth and pay you. And you come for 5 weeks and you mow my lawn and I give you $100 every time, and then you turn up on the 6th week and I'm like, no, I don't want to pay for it, I'm going to give you $3 this time. You might be a little bit pissed off. Now, you might be able to identify some kind of recurring pattern and identify some sort of contract there, but for this example, it's completely discretionary. So, some terms look like they might be illusory but probably aren't. So where a party is given some sort of latitude of choice but isn't complete or unfettered discretion. Think about Masters and Cameron here, for example. I think I'm picking the right case in my head, where it was, we'll add such terms in as my solicitors think are appropriate. So there is a discretion to add additional terms, but it's not an unfettered. They needed to be consistent with the essential terms that were already agreed. Or the discretion relates to the fulfilment of a condition on which performance depends. So if I say, and this comes up in, actually it's Meehan Jones is not the one I'm thinking of, I don't think, but this idea that subject to finance. So actually, let's see if that's, Meehan and Jones, it is Meehan and Jones. So this is a good example. So somebody's trying to sell the land. The contract itself says that it's subject to finance, subject to receiving approval for finance on satisfactory terms and conditions in an amount sufficient to complete the purchase set out in the rest of the agreement. And if those conditions aren't satisfied on or before the 31st of July, then this contract, other than this clause, will be null and void. So Meehan basically, on the 30th of July, Meehan told Jones that both of those conditions had been satisfied. But Jones had actually Jones the vendor, entered into another agreement a few days earlier. So he argued, well, this unfettered finance that's suitable, it's an illusory promise. So the court basically said, no, actually, firstly, the finance was not for Mr. Jones, it was for Mr. Meehan. So actually, it's up to Mr. Meehan to decide whether or not that finance is on reasonable terms or not. If I'm borrowing the money, I can decide whether those terms are reasonable or unreasonable. If you're selling me something and I need to borrow money to buy it, if I borrow money on terms that you think are outrageously high, you can't say no contract. Okay, it's only reasonable to me. But secondly, the purchaser here, there's this implied idea that he has to act honestly and reasonably in deciding whether the finance is reasonable. So again, if the purchaser was offered finance at 1% interest and the purchaser says, no, that's unreasonable, I want to borrow the money and you pay me interest for looking after it, which would never happen, but they're the only reasonable terms on which I will deal with, a court would say, no, that's unreasonable. You're supposed to act honestly here. You have an obligation to go out and look for that finance, and if you get a reasonable offer, you should take a reasonable offer. But here also, because even if the term hadn't been completed, the purchaser would have had the opportunity to waive that, because that reasonable finance term was only benefiting the purchaser, so it could have been waived. Have a quick look at where we are. Now you can have a look at that one yourself, that's pretty straightforward. It's worth actually remembering this too, that terms like incomplete, uncertain or illusory are not mutually exclusive necessarily.